Well, welcome everyone. My name is George Constantine. I'm a partner here with Venable's Nonprofit Organizations Practice Group, and I want to welcome you to today's Nonprofit Organizations webinar, Building a Nonprofit Board of Directors, Legal and Strategic Issues. I'm sure this topic is going to be of great interest to those attending and others in the nonprofit community, and we're excited to have one of our nation's foremost nonprofit attorneys available to share this knowledge. I'll introduce Bob briefly, and then I'll join the rest of you in listening in on his presentation. Bob Waldman's a member of our firm's Tax and Wealth Planning Group. He serves as counsel to foundations, hospitals, educational institutions, trade associations, community foundations, and many other charitable entities, counsels companies on corporate social responsibility matters, and has a lot of experience on the International Philanthropy Front as well. Bob counsels clients very regularly on this topic, has had a wealth of experience. I've been a privilege to get to work with Bob over many years, and I'm sure you'll agree with me that his insights will be great for learning about the board issues and how to populate and build a board that is going to be effective for your organization. With that, I'm going to turn it over to Bob and let him begin, and I will leave. Thanks.
Right. Thanks, George. And good afternoon to everyone. So what we've noticed at Venable in our nonprofit practice over the last year or two, there's been an increased interest, focus on governance issues. And what I want to talk about today is issues that I think are unique to nonprofit organizations and some strategic things, some options, some things that we've seen clients focused on. So let me start with where do you find the information? Where do you find the rules on structuring a nonprofit board? Where do you start? And there are a series of places that come into play here. First, you need to be familiar with the state corporate code. And in many states, there's a separate nonprofit corporate code. Some don't. Some states just have one generic corporate code that applies to both for-profit and nonprofit organizations, but many, like a state like Delaware, but many states have separate codes. Second is there are IRS rules that come into play for nonprofit organizations that you need to be sensitive to, and I'll talk about those in a bit. You need to look at the articles of incorporation themselves and the corporation's bylaws to see what do they say about board structure and board rules. And finally, you need to look at board policies that the organization has adopted. So who are the players? When you talk about board structure, corporate governance in the nonprofit world, who are the players that you have to be thinking about? The first is, obviously, you start with the board of directors. Now, you'll see in nonprofits, some people will refer to them as board of directors. Some will refer to them as a board of trustees. And people will say, well, what's the difference? And the answer is there is no difference. It's just terminology. Some people refer to their directors as directors. Some think it sounds more charitable if you call them trustees. Personally, I like the nomenclature directors better because it avoids confusion where some people say, well, they're calling a board of trustees. Is this a trust? Or as opposed to a corporation. And some people will say, gosh, board of trustees, that seems like it has a higher fiduciary standard than directors, and that makes me nervous. So although there's really no difference between calling it a board of trustees or a board of directors, I personally like the nomenclature board of directors. I think that's probably the trend that you'll see. Again, in terms of players in the governance structure, you have officers. And a question that comes up from time to time is, do the officers have to be board members? And again, you'll need to look at the corporate code in the state you're in, but typically they don't have to be board members, although it is quite common to see in bylaws of nonprofits, they'll say that the president must be a board member. You don't have to do that, but that's quite common. Then, and I'll talk about this in a minute, there are what are called the members of the corporation, and I'll talk about that in a second. But typically, there are two types of members. When you talk about members of a nonprofit organization, there is what we think of as the corporate member. That's sort of the nonprofit equivalent of a stockholder. And that person is generally given certain rights that I'll talk about in a minute. So that would be the member of the corporation. But then those of you, in particular, those of you who are involved in trade associations are familiar with what I would call is the small letter members, people who basically don't really have any voting rights or real control of the corporation, but they have membership rights. They're entitled to certain things because they're members of the corporation. And that's a different kind of member. And I'll talk about that a little bit more in a moment. So I don't want to spend a lot of time on this, but let me start because my guess is you're all pretty familiar with this, and this is a subject onto its own, but just to sort of quickly talk about what is the role of the board of directors. So, as you know, the board sets the policy of the corporation, the direction of the corporation. One thing that's important is that the board monitors the investments and finances of the corporation. And I've seen this happen before, but there's a case that's somewhat famous for this where the nonprofit was invested heavily in tax-exempt bonds. And the question is, why would a tax-exempt entity invest in tax-exempt bonds? That makes no sense. Lower return. Yeah, it's not taxable, but the entity's not taxable anyway. And in that case, which involved a hospital, the board ended up being sued because they had invested heavily in tax-exempt bonds in a tax-exempt entity, so made no sense. But the board typically will monitor investments and finances, will have regular meetings. They'll maintain minutes of the board meetings, which you all are familiar with. The board will review the annual tax return and financial reports, should have some familiarity with the basic corporate documents, the articles and the bylaws and the board policies, and be familiar with the organization's grant making and their programs. So that's in broad strokes the role of the board. Now, in talking about board structures, who appoints the board? Well, there's basically two significant methods you'll see. The first and most common is what we refer to as a self-perpetuating board. That is, the board replaces itself. When people's terms run out, the board votes for a successor. And that's referred to as the self-perpetuating board, the most common model. The other is, and going back to what I talked about a minute ago, is where the board gets appointed by another entity. That is typically the member. And typically you'll see that in a system where the parent entity will appoint the board of subsidiary entities. And that'll be spelled out in the articles and bylaws of the nonprofit that it is the member of the corporation who appoints the board. You'll also see typically in nonprofit organizations what we think of as ex officio board members, people who are on the board because they hold a certain title. And that could frankly be somebody who's an officer of the corporation. It might be a government official. It might be somebody who holds a position automatically because they have a certain title. And when that title changes, that person no longer has that title. The next person automatically becomes a board member. Those are ex officio board members. And then in some nonprofit boards where you'll have classes of board members, and each class will appoint its successors, so that maybe there's a class of founding board members and they appoint their successors. Maybe you'll see this typically in a family foundation where maybe the family appoints certain board members and maybe there are outside board members also who replace themselves. So that's when you have class appointment. What about ancillary boards? So in addition to the full board of directors, typically or sometimes you'll see other board structures. And ones that you may be familiar with there'll be an advisory board. These may be people who you really don't want on the operating board of directors, but you want their advice from time to time. And in some ways is more ceremonial, but they're put on an advisory board. And the advisory board, maybe it meets a couple times a year with the CEO to give their thoughts, share their insights, to be caught up on information. And that's your advisory board. I think it's a valuable structure for people who either A, you don't necessarily need on your operating board, who don't want to be on your operating board, but you want their input. Then there may be honorary board members. These are people who, again, are, because of the position they hold, or maybe they're a government official, maybe they're an elected official, and you want them to be able to have on their resume, and frankly, you want to hold them out as having a relationship to your organization. They're an honorary board member. There are board emeritus members. Those are people who have now termed off of your board, but they still want to have some affiliation, and they're referred to emeritus board members. Now, in those three categories, the advisory board, the honorary board members, board emeritus, typically have no voting powers and don't count for the quorum. They may attend meetings on invitation, but don't necessarily show up for meetings. And the board you can decide whether you want to send them board material so they're up to speed on what's happening with the organization, or you might send them selectively to those people. But again, all common structures in structuring a nonprofit board. Now, let's talk about what is the right size. What is the optimal size for a nonprofit board? So again, you start with looking at the state corporate statute of where your organization is incorporated, because that may set rules on what is the board size. In my experience, typically the state statutes don't set a limit on board size. They'll say you must have at least one board members. But typically what they'll do is say, let's look at what the bylaws provide in terms of board size. Typically your bylaws will say the board can be as few as X and as large as Y. And it may say you can have as few as 3 or as many as 25. So you need to look at the bylaws as what do they say for how big can the board get? Now, what's the benefit? What's the optimal answer here for a nonprofit board? And again, obviously there is no right answer here, but let's talk about for a minute, what are the advantages of each? So what are the benefits to a smaller board? Well, obviously it's easier to meet. If you only have 5 board members, it's easier to get them together as opposed to if you have 25 board members. I've represented organizations that have as many as literally 100 board members. Trying to get them together is not easy, and trying to get a quorum virtually impossible. So it's much easier to meet with a smaller board. Also, smaller boards tend to be better informed. You got fewer people to provide information with. They tend to be more engaged. They tend to be more involved in the operation of the organization. So they tend to be better informed. And again, pure efficiency. So you need a quick board meeting because something's popped up and you need something quick. So getting together a small board on a short notice is obviously easier than a large board. But what are the advantages to larger boards? Well, obviously you get the more people, the more ideas you get. You tend to get a more diverse board. Fundraising capacity, that to the extent you expect your board to get involved in fundraising or frankly to contribute themselves, more is better. And then frankly, it's the board fatigue factor, that if your board is too small and you've got lots of committees and you've got lots of meetings, and you're just going to burn your board out. So you may want a bigger board simply to spread the work. Now, let's talk about terms and term limits. And in my experience, that generally the state corporate statutes will defer to the bylaws on term limits, length of terms, how many terms. There are some states that do set limits on the length of board terms. I believe New York does, for example. Some statutes will say, a board term can't be more than 5 years. Many states have no limitations whatsoever. So, and some organizations we've represented, and you typically see these in organizations that have founders or key people, will have life directors that'll simply say, you'll serve for life. Very common in family foundations to have that sort of thing. So, what are the arguments for term limits? What are the advantages of term limits? Well, it provides new thinking. You can move people in. That importantly, in today's world, it gives board members a graceful way to exit the board. So, yes, and many of us who've been on boards can have this. It's very hard to, it's embarrassing to say, hey, I've been on this board a long time, I'd like to get off. So having term limits gives you a way to gracefully exit the board. It also, because your board may say, well, we're only allowed to have 15 board members, having term limits gives you a way to get people off the board so new people can get in. And it prevents, and I think this is important, when people are on boards too long, a sort of sense of ownership sets in. I've been on the board forever. I know what's going on. You're new. You don't know what you're talking about. And it maybe inhibits or freezes new people from speaking up or presenting their ideas. So having term limits, I think, prevents that from people just staying too long and others feeling they're not allowed to speak or contribute. Now, what are the arguments against term limits? Well, it's hard to find good board members. It's not like people are lining up necessarily to be on nonprofit boards. And having term limits, sometimes you're going to lose some good people. And then again, some of these people may be your best funding sources. And if you force them off, well, then you lose that potential funding source. So what you'll see in many sets of bylaws will say, after you've termed out, you've spent your 3 terms of 3 years each, that after a 1-year break, you can come back on the board. And that's a fairly common structure. Other things that I've seen people do is saying, look, if we don't want to lose the funding sources, maybe what we ought to do is say, let's set up a foundation or an endowment, a separate corporation, and we'll move those people who have been good funding sources onto the foundation board, or let's move them onto the endowment board. That way we don't lose them. Now, how about voting and quorum? So typically the rule is that there is 1 vote per board member. Now, that's not necessarily the only option here. It is permissible in many states where board members can have more than 1 vote. And you see that sometimes done, but typically it's 1 vote per board member. And the normal rule is that the majority vote of the board at a meeting where the quorum is present passes an action. So what is the quorum? Well, typically it'll be a majority of the board, but according to state statute, it can be lower, and many states will provide it can go as low as 1/3 of the board is a quorum. So what's the advantage of majority versus a lower quorum? Well, obviously, the lower the quorum, the easier it is to get. Sometimes it's hard to get a majority of the board for a meeting. So 1/3 quorum is much easier to get together. What's the negative? If your quorum becomes too small, then you have a handful of people making decisions for the organization. So think about a board where you say, let's say it's a board that has 9 people, and you say quorum's 1/3, 3 people show up, and you need a majority of a quorum to pass something. So that means 2 people can pass something. So that's the negative to a small quorum. And can you have a supermajority requirement? Sure. And in many times you'll have that. Many times you'll say this vote or particular actions requires more than a majority vote. It requires a 2/3 vote. Sometimes you'll require it has unanimous vote. So it's possible to sort of fool around with quorum numbers and vote numbers on important things, particularly when you have provisions in your corporate documents that you really don't want to change. And you might say, look, this is really important. Frankly, you see this in family foundations a lot, where they'll say, these are the purposes of the organization. We don't want anybody to deviate from it. So you're required to amend these requires a supermajority of vote. And sometimes you'll say it requires a unanimous vote to pass it. And then, and this I've seen a lot more of recently, is voting by class. So you create classes of directors, and different classes have different voting rights. You may say that, well, on these types of matters, only the Class A directors can vote. Or it's quite common in these things to say, if you really want to make sure that the organization doesn't deviate from its purposes, you might say, this particular action requires the approval of all classes of directors. Now, the negative there is that also permits a class to veto actions. So the quote unquote founding class who says, look, we want to make sure that nobody can change things, that can also backfire in the sense that when that class wants to change something, they need to get the vote of the other class. And so that can act as a veto power. But it is a very common thing to have different classes of directors with different voting rights. And it's quite often quite possible to have a non-voting class of directors. And you'll see this a lot of times. I've seen this recently in family type foundations where the founders, the patriarch, the matriarch says, look, we want the kids involved, but we don't want them voting yet. Well, we don't want them to outvote their parents. So you create a non-voting class of directors. So that's a common way to do it. And let me mention for a moment, for those of you who want who are trying to get continuing education credit here, the code word you'll need is Board 2024, Board 2024. And I see questions are coming in. What I'm going to try and do is probably come to those at the end of our session, just for continuity's sake. So please keep putting them in the chat and I'll come back to them as we go through this. Now, let me talk about this concept of reserve powers, because this is an important concept. So in many nonprofit organizations, there will be a parent organization, typically, as we've talked about, referred to as the member. And there may be things that you don't want the nonprofit to be able to do without the approval of their parent organization, the member. And these are typically referred to as reserve powers. And reserve powers are spelled out typically in the bylaws of the nonprofit. And common reserve powers, things that you need the approval of the member to do, the parent organization, are election of directors. It may say that the parent organization, the member, has to approve the election of directors. Any amendment to the articles or the bylaws of the nonprofit have to be approved by the member. That's a reserve power. Extraordinary corporate actions, that if there's going to be a merger, a dissolution, an acquisition, we want the member to have the right to approve that too. Significant loans, frankly, selection of the auditor, I've seen all of those as reserve powers in the member. So think about that as a way of it acts as sort of a guardrail on the nonprofit by saying certain really important things we want approved by the member. Now, what are the qualifications for being a board member? Again, these largely turn on what the state statute tells you, and the state statutes are found in the state corporate code. Again, look for whether there's a separate nonprofit code, but they'll be in the state corporate code of the state you are incorporated in. And is there an age requirement to be on the board? Not necessarily. Some states might say 18, but many say there is no age requirement. Anyone can be on the board. Do you have to be a US citizen to be on the board? Most states will say not necessarily. In fact, I would say that's the clear majority will have no requirement that you be a US citizen to be on the board. Other qualifications of board members, you might want certain skill sets, and it's very typical, as you know, for boards to keep nonprofit boards to keep a matrix of what skills are already on the board and what are you missing. You know, they'll always say, "Oh, we need a lawyer on the board. We need an accountant on the board. We need a someone who has HR experience on the board." One that obviously has taken a more significant role in the last few years is diversity and DEI principles. And something I've seen some of our clients start to do recently, which I think is clever, is they will survey their board members and say, are you have an interest in being, assuming a leadership position on our board? Do you have any interest in being a chair of the board? Do you have any interest in being a committee member, a committee chair? Because sometimes you'll overlook people when boards will just say, "Oh, well, who's been here the longest? Who's got the most seniority? Let's make them the chair. Let's make them the vice chair." And you'll forget about people who are very qualified, but maybe haven't been on the board as long. And I think that's a clever way and an important way of trying to make sure you've got diversity in leadership roles on your board. So let's talk about these board positions. So typically a board will have a chair and a vice chair. And the question that comes up is, are these now officer positions? And the answer is not necessarily. In other words, if you look at a typical corporate code, a nonprofit corporate code of Delaware, of New York, of California, they'll say to you, here are the officer positions that a nonprofit must have. It has to have a president. Maybe it has to have a secretary. Maybe it has to have a treasurer. And then it'll typically say, and whatever other board positions the board wants. But the chair and the vice chair of the board are not necessarily officer positions. They're really, if you think about what does a chair or vice chair do, they really run the board meeting. They're not necessarily officers. Now, you can make them officers if your bylaws provide. Your bylaws could say, oh, the officers of our corporation are the chair, the president, the vice chair, the treasurer, the secretary, but they're not necessarily officer positions. And that's an important distinction. I'll come to it in a minute why that's important. But now people typically will start, or I've heard more commonly, start to refer to, I'm the executive chair, or I'm an executive vice chair. And they're tending to talk about chairs who often also hold operating positions or officer positions. But keep in mind that the chair and vice chair are not necessarily corporate officer positions. And that's important, and I'll come to it in a minute why that's important. Now, let's talk for a minute about conflicts of interest for board members. And most of you in your organizations have a conflict of interest policy, which will have a detailed process in it for resolving potential conflicts. And when we talk about conflicts of interest, we're typically talking about, is there an economic conflict of interest? Does the director have an economic interest in a transaction that the board is considering? Or does their family have an economic interest? There's also what is called the corporate opportunity doctrine, that we want to make sure that the board member is not usurping a corporate opportunity that really should go to the nonprofit board that they sit on. So for example, somebody comes to the nonprofit and says, I've got a neat opportunity here where I'd like to provide a marketing opportunity for you to raise money. And the director says, man, I'd really like to have that one. Maybe I'll take that opportunity. That's the corporate opportunity doctrine. Board members cannot take an opportunity that was presented to the board, to the nonprofit corporation, for themselves. And I've seen that happen from time to time, particularly in marketing things, where the board member will say, well, somebody will come and offer a marketing opportunity to the nonprofit, and the board member will take that opportunity for their own business. That's the corporate opportunity doctrine. You can't do that. And the typical rule is that the conflicted director can participate in a discussion, in the board discussion of the matter to provide information, but then recuse themselves from the vote. Now, let me talk for a minute about, and this is only relevant to private foundations, but it's a really good rule of thumb for, I think, all nonprofit corporations and nonprofit boards. But these are unique to private foundations. That is your typical family foundation or corporate foundation. That foundation assets can't be used to provide an economic or commercial benefit to the directors. That you can't take the foundation dollars and use them in a way that benefits the directors. The directors can get goodwill and good public relations from the use of the foundation's assets, but not an economic benefit. So, for example, a foundation, a private foundation, can secure recognition for the directors. Let's say the foundation makes a grant to a hospital and they want to name it in honor of one of their board members. That's fine. That's not self-dealing. The IRS views that as what they refer to an incidental or tenuous benefit to the board member, but not an economic benefit. You can't use foundation assets, and frankly, this is a good rule for any nonprofit. You can't use their assets to secure business opportunities for the directors. So the foundation says, or the nonprofit says, I'll make a grant to such and such, provided that grantee turns around and gives business to one of my board members. The foundation, and again, this is a private foundation rule, cannot make a grant that satisfies the pledge or other obligations of the directors. Now, there's a really interesting, I don't want to get too far afield here, but there's an interesting question whether this same rule applies to donor advised funds, and watch for legislation on that one. So keep an eye out on that one, whether a donor advised fund can pick up a pledge of a related party. And the IRS has indicated informally that they might be willing to do that, but you at the moment, keep an eye on that. You really can't do that today. In a company-based foundation, for example, we at Venable have our own foundation, the Venable Foundation. So is it okay to make grants to charities where one of the directors of the company sits on the board, or a customer sits on the board, or an employee sits on the board? That's typically fine as long as it's not made contingent on getting additional business. And again, this is a foundation rule, but again, it's a good one to keep in mind that foundations can't purchase tickets to an event unless the people sitting at the table are all foundation representatives, or people who have a role in the foundation. In other words, you can't buy a table using foundation dollars and then let company employees or customers or frankly family members sit at the table. So this is really a private foundation matter, but it's a really good rule of thumb, I think, for all nonprofits to keep in mind in dealing with board members. Now, let me talk for a minute about what are called excess benefit transactions, because this applies to board members of most 501c3 organizations other than private foundations. Doesn't apply to trade associations. It's C3 and C4 organizations. So what the excess benefit rules say is that it imposes a penalty tax on transactions between nonprofit organizations and what are deemed disqualified persons, and that includes directors, where the value of the benefit the disqualified person gets is greater than the value of what the nonprofit is getting. And this applies to compensation arrangements, purchases, leases. So if a nonprofit leases real estate from a board member and pays more than fair market value, that's deemed an excess benefit transaction. If it overpays its board members, and I'll talk about this in a minute, that's an excess benefit transaction. And again, the disqualified persons who this applies to, or what the IRS says, is anybody who exercises substantial influence over the nonprofit, and that includes directors. Now, here's the bad news. If you have an excess benefit transaction, there's a 25% tax on the disqualified person, the person who got the benefit, and a 10% tax that's imposed personally on the board members who approved the transaction, up to $20,000. So that's one to keep in mind. If it's a sweetheart deal, there's a penalty tax on the person who got the good deal and also on the directors who approved that deal. Let me talk for a minute about, well, what do you do in a system where you have subsidiaries of your nonprofit organization? So one of the things you want to do, and it's quite often for nonprofits to have subsidiaries, is to maintain corporate separation. And but you want to maintain separation largely for liability protection purposes. So if you do have corporate subs, the best practice, and what the IRS recommends, is that there only be a minority board overlap. If you have identical boards of the parent and the sub, there's a greater chance that the IRS, or frankly in litigation over liability, that there'll be a move to collapse the two entities. This is called the proverbial piercing the corporate veil. So best practice is to have minority board overlap. If you have disregarded entities, i.e. limited liability companies under your nonprofit, sort of the same, you might not necessarily have a board of the LLC because you have managers. But again, best practice, don't have absolute overlap because it's it makes it more likely that the entities will be collapsed. So keep that in mind as a best practice. Now let's talk about board compensation. So it is permissible to compensate a board of directors of a nonprofit, but the compensation has to be reasonable. And there are lots of surveys out there about what does that mean. And typically what those surveys look at is they'll say, like, what is the asset size of the organization? What are their revenue sizes? And based on that, what is common to pay board members? And to be frank, typically it's not going to be an enormous number. Typically, many boards, as you know, and probably the majority of boards, don't compensate their board members. But you can do it. But again, you ought to look at these surveys. Or many boards will hire an outside comp consultant to evaluate whether what they're paying their board is fair. Now, some boards will say instead of compensating their board members, or in lieu of compensating their board members, will permit board members to designate a certain portion of the nonprofit's assets as grants. They'll say that's what your compensation. We're going to set aside $100,000 that each board member can designate where it gets contributed to, and that's how we will compensate it. It's a fairly common model. I've seen ones that are frankly give them a quite large number that they can exercise discretion over. One point, it's interesting. You don't see this that often, but I can tell you historically what I've seen is some boards will say we're going to buy an insurance policy on our board members and let them designate who the beneficiary of the insurance policy is. Let me talk for 1 second on this, and this is a little bit, and I apologize, this is a little nerdy, a little geeky, but you sort of are who you are in life, and that's who I am. So you may remember several years ago where the IRS, in their attempt to crack down on, frankly, on college football coaches, imposed this tax on compensation that a nonprofit paid in excess of $1 million. And everyone said, oh, that's not going to buy. No, what nonprofit pays more than $1 million? But what they do is, in calculating that $1 million, they will aggregate compensation you get from related entities. And quite often you'll have board members who from a related entity are getting compensation. And so the question becomes, are my board members of my nonprofit, when they aggregate compensation from related entities, are they going to be subject to this tax on compensation over $1 million? And the answer is, if you're only a board member of the nonprofit, that's not deemed an employee and you're not subject to this. But if you're an officer of the corporation, you are. So one planning technique is, if you're worried about this issue, it's a complicated issue, but if you're worried about it, making the person simply a director of your nonprofit, but not an officer, can be a solution here. So keep this one in mind. It's an important consideration. It's missed a lot, but keep it in mind. For, again, the important point is compensation over $1 million when you take into account related entities, and related entities is broadly defined. So keep that one in mind. Now, and I am going to come back to the questions that are in the chat room, but let me finish up and then I'll come back to those. Again, as a reminder, for those of you who are getting continuing education credit, the password is board 2024. So board meetings and minutes. So there is typically no required number of board meetings. Some state statutes will say you got to have an annual meeting, but generally there's not a required number of board meetings. What is best practices? Typically, what I'm seeing in the nonprofits that Venable represents, typically you'll see 4 to 6 board meetings a year. I know of some that have monthly board meetings. I think that, frankly, I sit on a board that has monthly board meetings. It's like it could kill you. But typically you'll see 4 to 6. Sometimes in the off months they'll have executive committee meetings, but typically board meetings, 4 to 6 meetings a year. Important to have regular attendance of the board at board meetings. I've seen in some sets of bylaws, let's say if you miss X meetings, you're off the board. Minutes, I think, have taken a much more important role in board meetings. And again, although there's no magic answer here, the important thing is to keep only important information in your board minutes. There shouldn't be extraneous information. Board minutes are not a transcript of the meeting. I can tell you, I've had several cases where lawsuits have resulted by putting too much information in the board meetings. In the board minutes, I've had one that was a defamation thing because they put in the board minutes that a potential grantee was an idiot. They found out, he sued under a defamation theory. I've had discrimination lawsuits brought because people put too much information into a board, and irrelevant information into board minutes. Somewhere, I've now concluded, and I've gone back and forth in that, somewhere, not necessarily in the minutes, but maybe in the notes, you ought to keep a record of the board vote, so that if it ever comes up who voted in favor, who voted against, somewhere there is a record of it. Let's talk for a minute about D&O insurance, directors and officers insurance. I think it's a good idea for nonprofit boards to have D&O insurance, but you need to be clear on what does the policy cover, because quite often you'll be surprised at what it doesn't cover. Really important to have employment claims covered, because that's probably the most common area of liability that most lawsuits are employment-based in nonprofit worlds. You want to be clear that it covers your legal fees, because frankly, that's probably the board's biggest exposure. Very hard to sue the board, very hard to find this, absent fraud, hard to sue, hard to find the board liable for something that happens in the nonprofit, but they're going to have to defend it. So you want to make sure that have legal fees are covered. One thing that unfortunately has come up more often recently, you ought to check whether your D&O insurance covers sexual assault cases. As you know, if you read the paper, in the unfortunate state of our world, more and more of these cases are being brought. It's fairly common that D&O insurance does not cover these cases. So you might want to look at your policy. And again, you may need, outside of your D&O insurance, a separate fiduciary policy. If your board also serves as, for example, trustees of pension plan or the 403B plan or whatever, you might need a separate fiduciary policy. Lobbying and political activity by the board. Now, particularly in an election year like this one, board members are permitted to, in their personal capacity, to engage in lobbying and political activity. They can do it in their personal capacity, but you need to be careful that they're not attributing it to their board position. So for example, if they write a letter to the editor endorsing a particular candidate, it shouldn't say on their signature line, board member of XYZ charity. Or when they go to meet with an elected official, they shouldn't walk in and say, oh, by the way, I'm the president of the such and such board, because that will be attributed back to the nonprofit. And as you know, nonprofits cannot engage in political activity and can only lobby to a limited extent. So want to be careful that your board's aware that if they're lobbying or in political activity, they shouldn't be identifying the board. Now, there are times where they do lobby in their board capacity, but that ought to be a conscious decision that the board is aware of. Resignation, removal, and vacancies from a nonprofit board. Again, how do you do it? It's typically spelled out in the bylaws. There may be state corporate law provisions on how you go about resigning or being removed. Important that when you do submit your resignation, that you specify the effective date of the resignation, or it should say in your bylaws, if you don't specify one, that it'll be deemed on the day your resignation is sent in. That's the effective date of your resignation. Board policies. So what are common board policies? So we've talked about conflict of interest. One that I think there's an increased use of, and I think it's a good idea, is a confidentiality policy. Your board gets lots of confidential information. And although as a matter of course, board stuff is confidential, I think a lot of nonprofits are having their board members sign specific confidentiality. It could be a very short thing where they recognize that everything you get on confidentiality, all the information you get is confidential. It's not a bad idea to have the board sign that. Gift policy. This regulates whether a board can receive gifts from vendors, from grantees, and a lot of boards are adopting this, saying, no, we don't want our board members accepting those things. We don't want them being taken to the football game. We don't want them being taken to dinner, because it puts us in an awkward position. And then there can be a board compensation policy. How is compensation of board members going to be determined? Now, again, what's a little bit awkward on that one, and a lot of organizations find this, is because everybody on the board is compensated, who's going to approve it? There's nobody to approve it who's not compensated. So in any event, those are ones that we're seeing a greater use of. Lastly, let me talk about the use of board committees. And there are two types of board committees. There are what are called board committees. Those are ones who exercise the power of the board. And those typically are restricted to having only board members on those committees. Then there are advisory committees who anything they recommend has to go back to the board. And that's called an advisory committee. And those can typically have non-board members on them. But you ought to be clear which committees are board committees versus which are advisory committees. And then in organizations that have multiple entities, that have subsidiaries, so that you don't have multiple duplicative committees, you think about using joint committees of the board. So there's one audit committee that serves for all the board, all the organizations. There's one finance committee. There's one nominating committee. So you don't end up with multiple committees. So let me stop there and let me go back now and try and answer as many questions it's got about 10 minutes left. Let me try and answer as many of the questions that have been posed in the chat as I can. So recommendation on term limits. Do most nonprofits have term limits? I would say the trend is yes, term limits. Again, as the person who posed the question asked, it's tricky because it is hard to find good board members. But again, I think term limits gets people off, gets people, new people in, and keeps boards from getting stale. Now, what is the most common term limit? What I'm seeing mostly these days is either 2 terms of 3 years or 3 terms of 2 years. And is there one better than the other? Depends on your organization. Some organizations takes longer to figure out what's going on. I've sat on boards where it's literally taken me 2 years to have any idea what's going on, and by then your term's over and you're off. So, but I'm seeing typically 2 years, 2 terms of 3 years, 3 terms of 2 years. I've seen some that have 3 terms of 3 years, 3 terms of 2 years, but that's kind of what I'm seeing. You mentioned state codes for a board of directors. Where do I get the state codes for board requirement? Again, it's in the state corporate code. If you look at whatever state you're in, Delaware, look at the corporate code. California, just Google California corporate code, and you'll see some have separate nonprofit codes, and you want to make sure you're looking at those. Question is, understanding of ex officio members of the board or board committee means the person serves by virtue of the office they hold. That's correct. Such as the president serving as an ex officio member of all board committees, even though they're not a board member. Am I correct that if Robert's rules applies, ex officio members have voting rights in these circumstances? Typically, it'll be what your bylaws say. And if your bylaws say, we're going to go by Robert's rules, and Robert's rules say ex officio members are voting members, then you're right. But typically you will say in the bylaws that ex officio members have voting rights, but look what's in the bylaws. Does the corporate opportunity doctrine apply to advisory boards? At my organization, we have members of the advisory board who run, for example, a communications company, and we want to give that company a contract to run a public service campaign for us. That's not the corporate, that's the conflict of interest. Are you paying these advisory boards for their service, and are they getting to vote on whether you hire them? That's the conflict issue. Typically, advisory boards don't vote on those kind of contracts, so you're okay. So you ought to be all right with that one. Says, question, many private foundations in lieu of direct compensation directors permit the directors to designate grants that the foundation funds in the name. Yes, that's a common, I've seen that's a common process. Again, the question is how much money you're going to give them the right to vote, but I've seen that quite often. Can a nonprofit that's associated with or deemed a religious-based organization make membership in that religion a qualification for board members? The answer is yes, they can do that. But I will tell you something to watch for. This is a little outside the scope of this and probably the source of a whole nother webinar, which maybe we'll do, but in a very evolving area that I've seen lots of people focused on, we're focused on a lot with our clients. Since the Supreme Court struck down affirmative action in its case involving Harvard and the University of North Carolina's admission process, nonprofits very focused on whether you can still have race-based or ethnic-based programs, and does that violate the Supreme Court decision in those cases? This is truly an evolving area, literally evolving day to day. Lots of litigation out there, lots of challenges to, and lots of questions about it. But for those of you who have programs or grants or whatever that are either race-based or based or targeted to a particular ethnic group, keep watching this space. There's lots going on in that area. We're doing a lot of work in that area. I wish I had answers for you, but it's so new and so evolving. Keep an eye on that one. That's a hot one. Have you actually seen enforcement of excess benefit transactions? I don't think I've ever heard of a case. Yes, I have seen it in IRS audits of nonprofits where they will raise that issue, that they'll say, particularly in compensation areas, you're overpaying, we're going to bring the excess benefit. A purchase was above fair market value. I have seen that in IRS audits, so it is out there. It says you touched on a minority board overlap between a parent and sub nonprofit organization, but is there a best practice with regard to allowing members of a parent organization to serve on the board of the sub? I think best practice is it's okay, but you want to make sure you don't have a majority overlap. You can have some people and frankly, it's very common, and frankly, there are good reasons to have members of the parent board serve on the sub so that the sub doesn't go rogue and start walking away with your money or your program. But again, ideally, you would keep the overlap to a minority. What you might want to do, again, a little bit of inside baseball, is have maybe some former board members, people who are no longer on the board of the parent, serve on the sub board. Does a conflict of interest policy need to be re-signed annually? Probably best practice. I will tell you that many organizations don't do it annually. They only do it when new board members come on board. I think it's a good idea to do it annually because relationships change, new businesses change. This question is, when you keep record of a board voting, should you identify the voter as well as just the tally? Yeah, I've gone back and forth in my own mind on this. I think the best answer is in your notes somewhere to include who voted for what, so that if there's ever a question later, a lawsuit, whatever, and you want to show who didn't vote for it, probably ought to have that somewhere. It's a tricky one because you run the risk that who voted yay and nay will get out into the public, and that can have some political issues. But having thought about this a lot, I think somewhere it's a good idea to keep that who voted for and who voted against. What about paying the board for member travel? This is really tricky stuff. So I think it's a good, it's done all the time because board members have to travel to the meeting or board members have to travel to a site. I think you ought to have policies about what is reasonable expenses. We're not paying first class, we're paying for, middle level hotels. You can only fly first class if the flight is overnight or out of the country. But if it's domestic, got to be economy. The one thing you should never do is pay for spousal travel. That's a hot button with the IRS. So, but I think it's okay for board travel, but it's got to be reasonable. Ought to have a policy. If you're looking for a policy, email me. I'll try and send you a sample one. There are lots of them on the internet. Are you remarking that a member of how individual members voted? We talked about that. Is there an advantage to establishing a requirement for a supermajority to make bylaw changes or a disadvantage? Well, the advantage is it makes it harder to change the bylaws. And if there are things you really don't want changed in the organization, that's a good thing. Like let's say you want something that says you can never vote the family members out off the board, that you might want to have supermajority for that to vote a family member off. What's the disadvantage? It makes it harder to change the bylaws. So if it says in the bylaws, we're going to have 6 meetings and you want to change it to 4 and you need a supermajority vote, harder to do. So it's a little bit of a balancing act there. How often should the board review and update the bylaws? Great question. I think every 2-3 years, they ought to be looking at them and thinking about that. I'm just going to take a couple more because we're sort of hitting the end of the thing. For those of you who haven't, we do keep tabs of the questions, and I'll get back to those I don't get to. I apologize. But we got a lot more questions, so I'm going to get back to those. We have paid board seats, and these directors are pushing us to let them appoint alternates if they cannot attend board meetings. How common is it to allow for board alternate? This is a great question. Let me tell you, let me throw a nuance into it, a 2024 nuance. Question I'm being posed with more regularly is, how about an avatar that's AI generated? Can they attend the board? This is a great question. And, if you say, I'll do mine first because I love my question. Can an avatar show up and attend the board meeting? So if the avatar is only there to take notes or listen in, that's no different to me than dialing in on the phone. So I think that's probably okay. But if the avatar is going to record the meeting, big problem. Because that's just setting you up for lawsuits. You don't want board members recording, having their tape recorder reporting a board meeting. So keep an eye on that. can you appoint a surrogate to come for you? See, where you see this quite often where some of your board members are like elected officials and they can never come to the board. I think in those cases, it's probably okay to have a staff member attend the board. But outside of that, I don't think it's a good idea. Let me take one more question and then the rest of you, I apologize. I want to be respectful of time. The rest of you I will get back to, but we got a lot more questions to go to. Should the board approve the conflict of interest policy applicable to the employees? I don't think so. I think that's really a management function. And I would let the management do that. I don't think that necessarily rises to a board level. So let me stop there. We're at the bottom of the hour and I want to let you all go do your stuff. Appreciate your really, and I will get back to this. We've got lots more questions that I haven't gotten to. I will get back to you all. Again, for those of you with CLE, the password is board 2024. Appreciate your coming. We'll have another one of these next month. So keep an eye out on that one and keep watching this space. We do these monthly. Obviously we enjoy doing it and we appreciate your attendance. So let me stop now. Have a great afternoon all. And again, I apologize. I will get back to you. We got a lot more questions and I will get to them. So thank you for listening in and it's good to be with you today.